Very good morning. Today we are starting the lecture number 3 for post-graduation program in export import management. In earlier two lectures, we have been described you regarding the basic infra which is required for export import businesses and what are the export import conditions before and after 1981. Today we are starting with the arbitration. What is all about the arbitration? What is the role of the Indian Institute of the Arbitration? And there are some other things which is going to be discussed in another 20-25 minutes. What are the outline of the presentations? Introduction, arbitral and non-arbitral disputes, duties of arbitrator, benefit and drawbacks, kinds of arbitration in India. So we have one body that is called Indian Council of Arbitration, undisputed leader in a dispute resolutions. As we know, if we will go with legal procedure, then it will be costly. As we know, ki suppose that whatever the international transactions we are doing from one country to the rest of the world, it might lead to create the numerous number of the dispute in a nearby future. And in a, every time we have seen in a newspaper due to certain misconception, due to certain miscommunications, dispute has been raised in international market. So we have a certain bond, we have a certain body, we have a concerned regulatory body which could manage the entire dispute system in terms of the international business. As we know, if we will go with the legal procedures, it will be costly, time consuming. Business dispute can take a real bite of your company's bottom line. Suppose that if we are proceeding with the legal procedures, it might take the longer time as what actually we are expecting. So that is the thing. Indian Council of Arbitration, they are mainly working for resolving the dispute. That is why more and more companies are turning to the Indian Council of Arbitration, the undisputed leader in a dispute resolution service in India. That is the only reasons that most of the multinational corporations, they are reaching out to the Indian Council of Arbitration just because of to resolve the dispute within the certain period of the time. The ICA was established in 1965 as a specialized at the arbitral body at the national level under the initiatives of Government of India. This is totally Government of India regulatory body and apex business organizations like a FICCI, etc. It was based in New Delhi. Still, it's based in New Delhi. The main objective of ICA is to promote the amicable, quick, and inexpensive settlement of commercial dispute by means of arbitration, conciliation, regardless of location. So the main objective of ICA is to provide to resolve the dispute in a very frequent manner. It should not be very expensive. It should be very quicker. Today, ICA is not the only leading arbitral institution in India. It is one of the most important arbitration center in Asia Pacific, handling more than 400 domestic and international arbitration cases each year. Every year, they have to be faced at least 400 domestic and international arbitration cases. It also provides the commercial world with an unrivaled and time-tested maritime arbitration services and impart education and training in an alternative dispute resolution mechanism. Coupled with it coupled with our quality case administration and panel of arbitration, ICA is one of the resources for all your dispute resolution needs. So Indian Council of Arbitration plays a very vital role in terms of the dispute resolutions. They are the only concerned body because it is totally apex body which is actually working under the Government of India guidance. Suppose that whatever the dispute has been raised in the international market, if we are going with the legal bodies or some legal procedure, so it might take the longer time. It might be very expensive also. That is the thing. Most of the multinational corporation as of now, they are approaching to the Indian Council of Arbitration for resolving the disputes. Who can be the arbitrators? Judges, advocates, engineers. We have a team of the numerous number of judges, advocates, engineers, chartered accountants, executives, maritime expert, businessmen, foreign nationals. So we have the numerous number of the different occupations. They belong to different occupations, but they all can be the arbitrators. Introduction. Arbitration is the process in which a dispute is submitted to an impartial outsider who makes a decision which is usually binding on both the parties. So all those persons who are playing the role of the arbitration, they should be the outside of the parties. Okay, and they are resolving the dispute in such a manner so both the parties can be both the parties can be what we call justifiable, and both the parties can be agreed on the decision, whatever the decision has been taken by the arbitration. Basics: arbitrator enforces his own point of view on the contending party, and the opinions of the participants are not given any predominance. Arbitration is a judicial process, yes. The award of the arbitration is binding and based on equity and justice. There is no scope for compromise. Yes, the award of the arbitration is totally binding and the based on the equity and justice method, and there is no scope of compromising. Arbitration process: case filed starting from arbitration selection process, preliminary hearing and scheduling the order, discovery process, hearing mediation, arbitration hearing, post arbitration briefs, final arbitration award. Suppose that there is a case between the India and China. India is thinking like this. India is thinking like that. China has cheated in terms of the international trade. What India can do? India can file the cases against the China in Indian Council of Arbitration. Firstly, we have to file the case filed. Then arbitration selection process will be start. Preliminary hearing and scheduling order should be there. Discovery process. In a discovery process, all those arbitrators who have been chosen for this particular resolving this problem, they'll try to they will try to do certain discover. They'll try to certain research and development on the behalf of the both the countries, and finally they will go for the hearing and meditation. Then mediation, arbitration hearing, post arbitration brief, and finally final arbitration award. What can be the arbitral dispute? Property, insurance, contract including employment contract, business partnership dispute, family dispute also can be done, except the divorce matters, construction and commercial recoveries. Here in terms of the export and import, we are more concerned about the property, insurance, contract, business partnership dispute, and commercial recoveries. We are more concerned about the family dispute and construction. What are the non-arbitral dispute? Matters of criminal nature. Whatever the matter which is in the nature in the criminal, we will not be handle those cases. Dispute relating to the matrimonial relations. Again, we are not going to discuss those issues. Testamentary matters relating to the validity of a will. Again, relating to the trust for a public purpose of charitable or religious nature. Insolvency matters relating to the guardianship of a minor or lunatic, and any execution proceeding. So these are the dispute which is not going to be come under the arbitration. Now, what are the duties of the arbitrator? To administer the oath to the parties and witness the appearing, to act the judicially and impartially. We should not take the any favor of any party. Suppose that there are two parties are involved in any dispute. So being an arbitrator, we should not take any what we call favor or partition of any parties. So what being an arbitrator, it is our basic rule. We have to behave as to act as a bar, judicially and the impartiality, to put necessary interrogatories to any parties to the dispute, to determine why and to whom the cost of reference and the award shall be paid, to award the interest, to fix amount, mode and time of payment. What are the arbitrator is doing? Hold hearings, issue decision and grant awards, determine the facts and applies the rules and laws. Advantage of arbitration: choice of decision maker with the expertise, speed up. As I've already told you, suppose that we are proceeding with the legal cases, so it might take the longer time. So that is the thing. Indian Council of Arbitration, they are taking the very less time to resolve any disputes, and it also involve the very lower cost. There is a certain flexibilities, confidentially, less formal than court, preservation of the business relationship also. Disadvantage: limited. Yeah, they have the certain limited resources. Sometimes it might take them more time as compared to the what actually we are expecting. Lack of transparency. Cost: parties pay for arbitrator and agencies. Yes, party has to be paid the. Suppose that if we are making the 5 or 6% at the arbitrator, so the party has to pay the cost. Limited right for appeal, fewer means to challenge award, lack of formal discovery. Gentlemen, I take if you are both familiar with the arbitration procedure. Yes, Dad. So this is a videographic photo we are putting down just because of your understanding. Main type of arbitration: voluntary arbitration and compulsory arbitration. What is all about the voluntary arbitration? It implies that two contending party unable to compose their differences by themselves agree to submit the conflict dispute to an impartial authority whose decision they are ready to accept. Suppose that there is a conflict between party A and B, and they are not able to resolve the dispute, whatever dispute has been risen up. And so what they can do, they they both themselves, they submit their conflict dispute and impartial authorities whose decision they are ready to accept. So what they can do, they can submit their dispute to the Indian Council of Arbitration, and what they will do, they will follow the same procedure which have been told in the past slides. Essential of voluntary arbitration: the voluntary submission of dispute to an arbitrator, subsequent attendance of witness and investigations. The enforcement of an award may not be necessary and binding. Voluntary arbitration may be especially needed for dispute arising under agreement and contract. Second is a compulsory arbitration. What is all about the compulsory arbitration? Compulsory arbitration is the one where the parties are required to accept the arbitration without any willingness on their part. When both the parties are not ready to accept their fault, are not ready to for the mutual agreement. So what they do is, suppose that ki party A is making certain claim on the B and B is also making certain claim on the A. So they are not able to resolve the problem mutually. What they have to do, Indian Council of Arbitration, they will have to go for the compulsory arbitration. Compulsory arbitration is the one where the parties are required to accept the arbitration without any willingness on their part. When one of the parties as an industrial dispute feels aggrieved by an act of the other, it may apply to the appropriate government to refer the dispute to an adjudication machinery. So from this photograph, you can understand that this is not the voluntary arbitration. The Indian Council of Arbitration uh, taking the forcefully decision and taking the forcefully action for the compulsory arbitration. What are the essential of the compulsory arbitration? The country is passing through the grave and economic crisis. Industries of strategic importance are involved. Parties are ill-balanced. Compulsory arbitration leaves no space for strike and lockout. It deprives both the parties of their very important fundamental rights. So there is a very less chances of the strike in terms of the compulsory arbitration, and both the parties of their very important and fundamental rights. Other types of arbitration we have: ad hoc arbitration, institutional arbitration, statutory arbitration, domestic or international arbitration, and foreign arbitration. These are the 5 different types of arbitration which we are going to be discussing in the very next slides. First is the ad hoc arbitration. What is all about the ad hoc arbitration? When a disputes or different arises between the parties, course of commercial transaction, this arbitration agreed to get justice for the balance of the unsettled parties of a dispute. Got it? When a dispute or what is all about the ad hoc arbitration? When a dispute or difference arises between the two parties in course of commercial transaction, this arbitration is agreed to get justice for the balance of unsettled part of the dispute only. So this is all about the ad hoc arbitration. So whatever the unsettled part of the dispute, whatever the balance of the unsettled part, so they will try to, or we will try to arbitrate only those part. Institutional arbitration: there is a prior agreement between the party that in case of the future differences or dispute arising between the parties during their commercial transaction, such differences or dispute will be settled by arbitration as per the clause provided in the agreement. Third is a statutory arbitration. It is mandatory arbitration which is imposed on the parties by operations of law. In such a case, the parties have no option as such but to abide by the law of the land. So statutory arbitration comes under the compulsory arbitration. It is a mandatory arbitration which is imposed on the parties by the operations of law. In such a case, the parties have no option left as such but to abide by the law of the land only. Then domestic or international arbitration. Arbitration which occur in India have all the parties within India is termed as the domestic arbitration. Arbitration in which any party belongs to other than India and the dispute is to be settled in India is termed as the international arbitration. So there is a slightly difference between the domestic and international arbitration. In a domestic arbitration, both the party belongs to the India and cases comes under the Indian Council of Arbitration. But in terms of the international arbitration, there is a one party belongs to the outside of the country and the cases is coming under the Indian Council of Arbitration, that is called international arbitration. Foreign arbitration, when arbitration proceedings are conducted in a place outside India and the award is required to be enforced in India, is termed as a foreign arbitration. When the arbitration cases is going to be uh, go outside of the India, that is called foreign arbitration. Thank you so much for joining. If anyone is having a doubt, you can ask. So this is all about the arbitration, Indian Council of Arbitration. What we have discussed today, I'm just telling you in the next 2-3 minutes. We have started from here. What is all about arbitration? I've told you what is all about the role of the Indian Council of Arbitration, undisputed leader in dispute resolution. Who can be the arbitrators? Judges, advocate, engineers, chartered accountant, executives, maritime expert, businessmen, foreign national. Then I've told you introduction. What are the basics of arbitrators? Arbitration process, case filed, arbitrator selection process, preliminary hearing and scheduling order, discovery process, hearing, arbitration hearing, post arbitration briefs, final arbitration awards. Arbitral dispute, property, insurance, contact, including employment contact, businesses, family dispute, construction, commercial recovery. These are many things we have discussed in the last 25 minutes. So, main type of arbitration, voluntary and the compulsory. And other type of arbitration, the ad hoc, institutional, statutory, domestic and foreign. This is all about today's lecture. Thank you so much for joining. Take care.